to the YouTube.
Okay, we are set. Everything is on, Ted. I'm going to mute now.
Okay.
Go ahead.
Let me synchronize the clocks. We're good. Okay. Good evening, ladies and gentlemen. Welcome to a regularly scheduled meeting of the Zoning Commission of the City of Danbury, December 12th, 2023 at 7:30 p.m. Let the record show we will begin with a roll call at 7:34. Commissioner Bennett.
Here.
Commissioner Botello.
Here.
Commissioner Cabrera.
Here.
Commissioner James.
Here.
Commissioner Jowdy.
Here.
Commissioner Nazario.
Here.
Commissioner Nejame. Oops. Well, Commissioner-elect Nejame.
Here.
Commissioner O'Neill.
Here.
Commissioner Harrison.
Here.
Commissioner Simone.
Here.
Commissioner Villacrest.
Present.
Wow, beautiful. Everybody's here. I think for the record, I want to mention that Commissioner-elect Nejame has not been sworn in yet. He is scheduled to be sworn in, so he technically is a visitor looking in this evening. Okay, so let me mention that the next regular meeting is scheduled for January 9th, 2024. If we can all stand, I have a flag at the next meeting. If anyone wants to bring flags, they can while we do the pledge, and I will begin with the pledge. I pledge allegiance to the flag
of the United States
of America
and to the republic
for
for which it stands, one nation, under God,
indivisible, with
liberty and justice for all.
Thank you very much. Everyone should have received the minutes of the November 28th, 2023 meeting. I know that the new members are not familiar with that meeting. Nonetheless, we're going to have to take a vote on the acceptance of those minutes. So, commission members, do I see a motion to? I got the YouTube just came on. Is there a motion to accept the minutes of November 28th, 2023?
Yes.
Motion
Make a
made
motion.
by Commissioner Botello, thank you. Is there a second?
I'll second it.
Second by Commissioner Bennett. Any discussion? Any additions, deletions, modifications? The only note.
Mr. Chairman, can we just make
Yes.
a note of there was I know this is very minor to everybody, but there was I guess a statement in the minutes about my retirement in
Yes.
March. I'm actually retiring at the end of February. So
It's actually
I
the
just want to make that amendment. That's
second to last paragraph. Mrs. Cleacher announced her retirement at the end of March. It's the end of February. So
all. I'll fix it, Sharon.
with
I'll
that
fix it
change,
tomorrow before I file them.
with that modification, do we still have a motion as amended? Commissioner Botello, yes, and
Yes.
Commissioner
Yes, we
Bennett,
do.
yes. Any other
Yes.
discussion, additions, amendments, modifications, changes, comments? All those in favor signify by saying aye.
Aye.
Those opposed. Let me read, since this is a Zoom meeting, let me read the instructions. The meeting of the Danbury Zoning Commission is being held on Zoom as a virtual meeting. Even though the meeting is a virtual meeting, members of the public and interested parties continue to have the opportunity to participate in the meeting in a couple of different ways. You can participate via Zoom and see the audio and video, or you can call in by phone and participate via audio only. Please be aware that we may have to mute your microphone or telephone to avoid an echo or some other background noise. This is also being streamed live via YouTube. Instructions on how to participate in the meeting appear on the City of Danbury website. And all of the documents and materials that apply to the matters to be discussed during this meeting, including the agenda, are also available on the City of Danbury website. As always, if you have any questions, please contact the City of Danbury Planning and Zoning Department. As a reminder, the entire meeting will be posted on and can be seen on the City of Danbury website. We will follow the posted agenda as per standard practice. If prior to the meeting, any questions or comments on agenda items were submitted via email to Sharon Calitro, those comments will be read during the appropriate portion of the meeting. Finally, please remember that technology glitches sometimes do occur. Please be patient if that happens. Couple other things, commission members. It's just us during the session. I don't see anyone from the public here. So if I ask for hands, you don't have to go to the hand button. You could just raise it in the screen. If you have comments or want to talk, and you'll be recognized. And if not, usually Ms. Reed or Ms. Calitro will say, "Whoa, hold on, you missed someone." So we'll catch everybody. So you don't have to click any buttons like that. Did the minutes, did the instructions. All right, let's get on to under organizational business. Oh, by the way, this agenda was filed in the town clerk's office on December 6, 2023 at 12:43 p.m. A nomination and election of chairman and vice chairman. We do this every 2 years. So I will now ask, and everyone is welcome to unmute. Why don't we all unmute now? And we'll go back on mute when we have the presentation by Corporation Counsel. So everyone unmute your mics. And let me ask if there's any hands for anyone wishing to nominate anyone. Do I see any hands for anyone to nominate? I see a hand of Commissioner James. Do you have a nomination?
I nominate Theodore Haddad Jr. as chairman.
Thank you very much. There's a nomination by Commissioner James to nominate Theodore Haddad. Is there a second to that? I see a second. I see a hand by Commissioner Nazario. A second by Commissioner Nazario. Are there any other?
A second.
Thank you. Are there any other nominations for chairman? Any hands? Any other nominations for chairman? Any other nominations for chairman? Is there a motion to close nominations? I see the hand of Commissioner O'Neill. Motion to close nominations. Is there a second? Second to close by Commissioner James. All those in favor signify by saying aye.
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 Let us vote, a voice vote on Haddad for chairman. All those in favor of Theodore Haddad for chairman, please signify by saying aye.
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 Any opposition? Not hearing or seeing any. Theodore Haddad will be chairman of the zoning commission. Thank you, commission members. Can I see any hands for a nomination of a vice chairman? Hands for a nomination of vice chairman. Commissioner James.
I would like to nominate Richard Jowdy as vice chair.
There's a motion made by, there's a nomination by Commissioner James for Richard Jowdy as vice chairman. Is there a second to that? I see a second by Commissioner O'Neill. Are there any other nominations for vice chairman? Are there any other nominations for vice chairman? Are there any other nominations for vice chairman? Not hearing any or seeing any hands. Is there a motion to close nominations for vice chairman? I see motion by Commissioner Nazario to close nominations for vice chairman. Is there a second to close the nominations for vice chairman?
I would second that.
I see a second by Commissioner Bennett. Any discussion? All those in favor of closing nominations of vice chairman signify by saying aye.
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 Any opposition to that? So nominations for vice chairman are closed. I will ask a voice vote. Is everyone in favor of the nomination for vice chairman of Richard Jowdy signify by saying aye?
Aye.
Aye.
Is there
Aye.
any opposition to Richard Jowdy as vice chairman? Not seeing any hands or hearing any voices. Commissioner Jowdy, congratulations as being vice chairman.
Thank you.
Ms. Calitro, Ms. Reed, is there anything else I'm missing before we go to setting of the effective date for approvals? We're good so
No,
far?
I think you're good.
All right, so let me find that in my pile. So commission members, we all received the 2020. Oh, no, nope, that's not. Ms. Calitro, can I ask you, what is our common practice?
Hi, everybody. Who doesn't? I haven't met some of you. I'm Sharon Calitro. I'm the planning director until the end of February. So the practice has been that the effective date of an action by the zoning commissioner, the zoning commission, is the day following publication unless otherwise specified. So that's kind of been our practice. Once you take action, we have 15 days to get it in the paper. We do it, before then to make sure everything's covered. And then once it's in the newspaper, the effective date of whatever your decision is the following day. And that's what's been standard.
Okay. So thank you very much, Ms. Calitro. So commission members, what I would look for would be a motion to continue on our standard practice of how we set the effective date for approvals granted by the commission. Does anyone want to make that motion?
I'll make that motion.
Commissioner Bennett's making that motion. Is there a second? Second by Commissioner Jowdy. Any discussion? The only thing I'll say under discussion is I think it's always worked for us in the past. I think even beyond the last 2 years. So I think it's a good move to keep it that way. Any other discussion? All those in favor signify by saying aye.
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 Those opposed?
Aye.
Not hearing any opposition or seeing any hands, that passes unanimously. So now we're going to go to the appointment of a ZBA subcommittee. So the zoning commission members, we have a subcommittee of 3 members. We get referrals from time to time. I think some of our powers have changed in the past where we don't get it that often, which I think Ms. Calitro, if we're lucky, we'll get maybe 4 to 6 in the next 2 years, something like that.
You probably won't get that many. It
Probably
mainly
won't.
has to do with like use variances that go before the zoning board of appeals, and then they have to get a report from the zoning commission. So maybe 3 in the last 2 years, maybe.
Yeah.
If that.
So I would ask senior member Vice Chairman Jowdy, I'd like to see if Commissioner Botello would be interested. Commissioner Bennett, do you have any interest in this before I
I would.
Yes, sir.
Also, yes.
Okay. I also want to put Commissioner Villacrez on that as well. So we're going to have 3 of the regular members, which by bylaw we believe, and I did check it out, we have to have, but it also allows for an additional member. And Commissioner Villacrez, you did express an interest in this, which we're all very excited about to see you wanting to get involved this way. So why don't we set the ZBA subcommittee as Commissioners Jowdy, Commissioner Botello, Commissioner Bennett, and Commissioner Villacrez. How's that sound to everyone?
Sounds good.
Sounds good.
So is there someone to make that motion that's how the subcommittee will be set up?
Can I make a motion?
Yes, sir, you can.
Okay.
Commissioner Botello is making that motion, second by anyone else second that? Second by Commissioner O'Neill. Any discussion? All those in favor signify by saying aye.
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 I don't see or hear any opposition, so we do have our ZBA subcommittee set. Under correspondence, I'm going to turn it over to Commissioner, I'm going to turn it over to Ms. Calitro, who's the Director of Planning. She is going to go over her memo and a little bit of a procedure and informational packet that we got from the Secretary to the Zoning Commission, Ms. Reed, and anything else that Ms. Calitro wants to go over at this time. So, Ms. Calitro, take your time.
Thank you. Thank you,
the
Mr. Chairman. Yeah. So I gave you, you might want to mute. Everybody might want to mute because I've had some feedback.
Yes, let's all mute now at this point, please. Thank you.
Thanks. So I provided to you a memo. It's called Notes to Zoning Commissioners. It has some information relative to the enabling statutes under Connecticut General Statutes, what you're supposed to look at, some case law. I don't want to get into the nitty-gritty of the memo because I think Attorney Casagrande and Attorney Edwards will go through that as part of their presentation. But it's there for you to look at things that kind of come up during the course of, regular action of the Zoning Commission. And so we'll take a look at it at your leisure. You can always call me with comments. I think it's covered in their presentation. If it's not, you can always give me a call. And at the end of my memo, there's just an outline of the zoning regulations. So the latest zoning regulations that we hot off the press because we had some amendments, and Jen is the Deputy Planning Director. And so she is not retiring, even though I am retiring. So, and she is in charge of the regulations and updating the regulations. So we haven't, updated. I think they're online updated, Jen. You can give me a nod. She hasn't been feeling well. So you can get them there. If you'd like a hard copy of the regulations, we can print them out for you in the office, put 3-hole punch them if you have a binder. And we can definitely provide that to you. We update them on, when you take action on them. So what I did was provide you an outline of how the zoning regulations are set up. And you can take a look at that as well. And just an introduction again to my staff, myself, Jennifer. We have an associate planner. She works with the Planning Commission, does a lot of the planning commission reviews under Jennifer. There's one of the assistant zoning enforcement officers, Tommy, is under RT and table of organization. Joanne is the planning assistant, and she has been here over 35 years. Her knowledge and institutional knowledge of the city of Danbury and what's going on is unbelievable. So she is a great resource. If you want to know anything, give her a call. And also we have a secretary, Melissa, who's somewhat new, 6 months or so to the department. She deals with the Environmental Impact Commission and the Zoning Board of Appeals. So I just want to introduce myself, my staff, little introduction about, notes for you, again, be covered by attorneys Casagrande and Edwards. And then Joanne also provided, there's some redundancy in the memos, and that's fine. Kind of we drill it in, put it under your pillow, it'll get there by osmosis. Just kind of the way we work. I'm really excited about working with you. I know I'll be here a short period of time, but I am available. You can just give me a call, shoot me an email. If you have any questions, come in. I know I've sat with Bruce, I've sat with Bob, over the course of time. If you have any, concerns, you have any questions about anything, feel free. Our doors are open, and I know that will be the case even when I'm not there. So with that, I think unless there's any questions, I'll turn it over to attorneys Casagrande and Edwards. And then once they're done, I will go over some requirements in terms of training that came out of some public acts. Just so you know, the training you're getting tonight will count towards your 4 hours of mandatory training that you have to have in by the end of the new members by the end of next year. FYI, Chairman Haddad and Commissioner Jowdy got their 4 hours this year, and Commissioners Botello and Bennett have a year from September. So you do have a little time because you're new members, but you'll have to self-certify at the end of every year that you continue to have some training. Again, this will count, and I'll go through the opportunities for additional watching additional videos or webinars to get you trained. So with that, I will turn it over. I'll turn it back to the chairman, or just over to Dan and Robin, whatever you want.
Thank you. Before we go to Attorney Casagrande, Attorney Edwards, also under correspondence, everyone has a copy of the 2024 meeting schedule, and the zoning commission bylaws were also distributed.
If I can, Mr. Chairman, actually, a note that we were discussing earlier, it does say under the meetings that unless otherwise ordered by the commission, the regular meeting shall be held in city. Well, it says actually in City Hall, but we have the authority. We have the authority under the statutes now to be via Zoom. So, but it does say at 7:30. So unless otherwise ordered by the commission, the regular meetings will be held at 7:30. So I guess you can change it under your direction decision.
Okay, we'll take that up when we next time we sit for business in the beginning of January.
Yep.
Excuse me, Mr. Chairman.
So I'm looking at January 9th. Yes,
Mr. Chairman, it's me. So I have everybody's address except Lexis, and she's going to send it to me. And then I will send you all the list again, and everybody's email is on it in case you need to get a hold of each other, I wanted you to have it. I just didn't have the list completed for tonight. I'm sorry.
No, that's fine. I had that under other matters I was going to mention. Everybody got a copy of it, but I just wanted everybody to look at it, see if they have any changes on it. Okay, you have that. So
Joanne?
Jody.
Rick.
my
Well-
email is wrong, so don't
Okay,
print it
well, we'll
yet.
talk later. I'll
Yep,
call you
You
later.
got it.
And then we'll
Okay.
get this
Okay.
updated and sent back out to everybody again.
Mhm.
Okay, great. That. And I did mention, everybody got copies of the, zoning commission bylaws, which we'll touch on, but it's in everyone's possession. So under other matters, we do have a matter, number one, a workshop session with Corporation Counsel regarding the zoning commission procedures. And here with us this evening, Attorney Dan Casagrande and Attorney Robin Edwards. And I will ask, them to begin their presentation, which, by the way, is absolutely fascinating and very, very, very well done. Compliments to Attorney Casagrande, Attorney Edwards, and maybe I'm just a zoning nerd, and I love it so much, but I think everybody here is going to really enjoy it quite a bit. And they're always available too, and they will explain that. So Attorney Casagrande, Attorney Edwards.
Mr. Chairman, I'm going to turn over the first portion of the presentation to Attorney Edwards, if I may.
Absolutely, you can. Hi, Attorney Edwards.
Hi, good evening. Thank you, Mr. Chairman. Good evening, members of the commission. For those of you who don't know me, my name is Robin Edwards. I'm an assistant corporation counsel, and my office is in City Hall on the 3rd floor next to the mayor's office. And I work with Sharon on a daily basis. Attorney Casagrande is our outside litigation counsel, also actually our corporation counsel now for the city. So we all work together closely on a daily basis, and Sharon knows how to reach me and where to reach me, and Jennifer as well, and Joanne at any time. So what we'd like to do this evening is to take you through what we call our workshop presentation that Mr. Haddad just mentioned, and I think you'll find it hopefully very helpful and interesting. We have a PowerPoint presentation, and Sharon or Joanne will provide you with the actual slides after the session is completed, if you wish to review them in further detail. So having said that, I'll get started. We'll ask you to hold any questions that you might have until the end of the session, because we may have covered some of your questions throughout our presentation. It is quite comprehensive. So first, we'll start with the basics concerning the Zoning Commission's powers and duties. The Zoning Commission is a creature of statute. Connecticut General Statute, Section 8-1, authorizes the municipalities to create local zoning commissions. The function of the Zoning Commission is to act in the public interest in zoning the different areas throughout the municipality and administering the zoning regulations. In Danbury, we have created the Zoning Commission through our charter, and that's reflected in Section 2 of our charter. You have 9 regular members and 3 alternates. You need a quorum to conduct business, which is 5 in this particular instance. What are the functions of the Zoning Commission? As members of the Zoning Commission, you act both in a legislative and administrative capacity. So in 2 fashions. In acting in your legislative capacity, you amend the regulations. So you adopt and amend the zoning regulations. You may get petitions before you on a regular basis to amend the zoning regulations. And in doing so, you will go through the standards as set forth in Section 10 of the regulations. The specific sections are noted here, and I urge you to take a look at those sections, read through them, familiarize yourself with them. Also, you act at times to amend the zoning map, and that is done in the same fashion, and those standards are also mentioned in Section 10 of our zoning regulations. And essentially, as commissioners, the Zoning Commission can amend or modify the regulations whenever time and experience reasonably indicate the need for such a revision. The Zoning Commission has broad discretion over the content of its regulations, but any amendments must be done in a reasonable fashion, and the regulation amendments must promote the public welfare. In acting in its administrative capacity, the Zoning Commission will hear special permits and decide special permit applications. And those are situations where the retail sale of alcohol is involved. And the particular instances that you might look at are applications for restaurants, liquor stores, cafes, taverns, grocery stores, package stores, breweries and distilleries, and brew pubs. So you will see those types of applications before you as well. Next, we'll get into a little bit of an overview of the zoning and planning process, provide you with a little history and the overview of the origins of zoning. Connecticut was one of the first states to enact statutes regulating land use, actually. And the first land use laws were enacted around World War I. So this was in approximately the late 1800s to early 1900s. There was growth in the numbers and concentrations of the urban population. And along with that, of course, came the congestion that comes with it, much like today, traffic, those types of things. So you had situations where industrial and commercial uses were beginning to locate in residential neighborhoods and vice versa. So the original zoning ordinances were actually nuisance abatement ordinances, which gradually evolved into plans for the overall development of the municipality in furtherance of the public interest. Planning was not widely used until about 1947. You all may have heard of the concept of Euclidean zoning, and the seminal case, of course, is the Village of Euclid versus Ambler Realty Company, and that is a U.S. Supreme Court case from 1926. And in considering that case, our Supreme Court upheld the rights of towns and cities to adopt regulations which divide a municipality into various districts. And much as we have today, segregating the residential, business, and industrial uses apart from each other. In this particular instance, the ordinance in question had changed the landowner's use from an industrial to a residential use, and it was diminishing. It diminished its value from its intended industrial use. The landowner in that case argued it was an unlawful taking of its property without due process. However, the Supreme Court in that situation held that such a regulation does not violate private property owners' due process rights because the regulation is in furtherance of the police power. And that is the power of a local government to protect the public health, safety, and welfare. So this type of zoning was upheld as a legitimate police power, hence the concept of Euclidean zoning, which forms the basis of dividing land in a municipality into districts and restricting the types of uses allowed in each such district. That's the concept of geometric mapping of districts on a zoning map. So that's an interesting bit of history. And what are the legislative roots of zoning in Connecticut? And so the powers, all the zoning powers are statutory. In other words, a municipality does not have any powers on its own to zone absent the statutes. And the zoning powers are set forth in section 8-2 of our Connecticut General Statutes. And that is another item that I urge you to take a look at if you have a chance or time to read through it and see what all the zoning enabling powers that are noted in the statute. And we can get you a copy of that certainly as well. I'm going to hit on some of the highlights that are listed in 8-2 or some of the general overall arching concepts to remind us of the overriding planning purposes of the zoning regulations. So I'm going to run through the major provisions for you now. First, a zoning commission may divide the municipality into districts, much as I just mentioned in the history of zoning, of such number, shape, and area as may be best suited to carry out the purposes of chapter 8- or the chapter regarding zoning and the statutes. And within the districts, it can regulate the erection, construction, reconstruction, alteration, or use of buildings or structures in the use of land. So the overall concept is to establish a plan that works for the community. Zoning regulations shall be made with reasonable consideration as to the physical site characteristics of the district and its peculiar suitability for particular uses, and with a view toward encouraging the most appropriate use of land throughout the municipality. And next I'll hit on the concept of uniformity. The zoning regulation shall be uniform as to each class or kind of buildings, structures, or use of land throughout each district. But the regulations in one district may differ from those in another district. The regulations have to have standards and protect the public health, safety, convenience, and property values. The regulations may provide that certain classes or kinds of buildings, structures, or uses of land are permitted only after obtaining a special permit or special exception approval. And certainly this is subject to the standards set forth in the regulations and the conditions necessary to protect the public health, safety, convenience, and property values. That's a very important point. The regulations shall be made in accordance with a comprehensive plan. And in adopting the regulations, the commission shall consider the plan of conservation and development, which is prepared under section 8-23 of the statutes. Next, I'll hit on some core zoning principles for you. As I just mentioned, one of them is the concept of uniformity, and that means the regulations must be uniform as to the district. The regulations within a district must be uniform for each class and type of use. So similar but different zones can have different requirements. The policy is that property owners shall have reasonable notice as to how the zoning regulations will be applied. The same requirements apply to all. There is no contract zoning. Conditions on zone changes are generally not allowed. There is no statutory provision to allow a zoning commission to condition zone changes on other actions or events. The principle of police power. The power to zone is not unlimited. Regulations must reasonably relate to the police power purposes of section 8-2 and will be declared a taking if they are so restrictive as to prevent all reasonable use of the property. That is a fact-intensive inquiry. The police powers allow legislation pertaining to property, but the uncontrolled use, because the uncontrolled use would be harmful to the public interest, but it can't go so far as to deprive a property owner of all use of their property. Vagueness. A regulation will be declared unconstitutional if it is too uncertain or vague as to provide a sufficient standard for enforcement. Strict construction of the zoning regulations. The zoning regulations, by their very nature, limit private property rights. Therefore, they must be narrowly construed in favor of the property owner. Permissive. Our zoning regulations are permissive, and what that means is that which is not expressly allowed is prohibited or automatically excluded. The comprehensive plan. The comprehensive plan consists of the zoning regulations and a map which divides the municipality into districts. All zoning regulations and boundaries must be consistent with a comprehensive plan. A simple way to say this is if you adopt a regulation or zone change, it must be in accordance with or part of the comprehensive plan. Public health, safety, and welfare. The key consideration in deciding whether to adopt or amend the zoning regulations or the zoning map is whether it would promote the public health, safety, and welfare for the residents of Danbury. And this was discussed in a recent decision, very recently released, the city was involved in, and that's the Lake Avenue extension versus the Danbury Zoning Commission, which Attorney Casagrande will hit on and discuss in further detail a little bit later in the presentation. Another important concept is the relationship of zoning to planning. Planning is critical to good zoning. The Planning Commission must adopt a plan of conservation and development, which is also called the POCD. And that's, as I mentioned earlier, pursuant to Connecticut General Statutes 8-23. It's a plan that's drafted by staff, approved by the Planning Commission. It's an overall plan for the development of the city. I also urge you to become familiar with that. And there was just a very, very comprehensive study that was done, and Sharon and Jennifer worked intently on that, and a new plan has been adopted. And basically, it's the guidance or the plan for the overall development of the community, what type of uses go where, what is the most desirable density of the population in the various districts of the city, what areas should be conserved, what are the goals for the physical and economic development of the city. All these things are considered. Basically, when the zoning regulations are amended, the zoning commission has to find that such an amendment is consistent with a plan of conservation and development. Now, the plan is a recommendation, but the zoning commission must consider it in adopting or amending the regulations and the districts. The uses allowed in a zoning district must be compatible with the stated purposes of the district, as noted in the zoning regulations and the plan of conservation and development. If this were not the case, the district would just become a combination of incompatible uses, which would destroy the integrity of the zone, reduce the property values, destroy the property owner's reasonable expectations. Bad zoning undermines the POCD and its health, safety, and welfare goals. Both the Zoning Commission and the Planning Commission have to consider the plan of conservation and development and make express findings on it when they are considering changes in the regulations or the zone boundaries. In other words, is the proposed change consistent with a plan of conservation and development? The next concept is worthy of noting, is this is a good point, is that zoning is not nuisance abatement. A nuisance is a use of property which is offensive and unreasonable. But zoning in and of itself is not nuisance abatement. Zoning has to be based on an overall plan that's in the best interest of the community. Just because a proposed use is not a nuisance, it does not mean that it's appropriate for a particular zone. And the example we have here is that a small office building may not be a nuisance to a surrounding residential neighborhood, but it may be inconsistent with the city's plan. Another concept is that the highest and best use does not control zoning decisions. The highest and best use is an appraisal concept. The highest and best use of a particular piece of property is not a controlling purpose of zoning, nor is a maximum possible enrichment of any particular landowner. The purpose of zoning is to control the use of land to promote the public interest. In other words, look at the public interest of the community as a whole. In Another concept you may have heard of is spot zoning, which comes up from time to time. And spot zoning is illegal. And the best way to describe spot zoning is as singling out for special treatment a lot or a small area of land in a way that does not further the comprehensive plan. It's a reclassification of a small area of land to allow a use not extended to other land in the vicinity. In order to survive a spot zoning challenge, the change of zone must be in accord with a comprehensive plan and reasonably relate to the police power purposes set forth in Connecticut General Statute 8-2. Spot zoning is inconsistent with the planning goal of an overall development plan in furtherance of the public interest. Now, the modern approach to spot zoning is worthy of noting here, and a court will not strike down a zone change involving a small parcel even when the change does not apply to other land in the particular zoning district, as long as the zoning commission determines that the change will further the comprehensive plan. In other words, is it in the public interest? So that's the modern approach to spot zoning. And what do you consider when you amend the zoning regulations or the zoning map? Remember, amendments to the regulations to allow use in a specific zone are effective not only as to the applicant's proposed or contemplated use of the property, but to all properties located within the zone. In exercising your legislative capacity, the commission can and should consider the amendment's effect on all properties in the city located in that particular zoning district. So a conceptual site plan submitted by an applicant with a zone change application does not limit the use of the property if the change is granted. In other words, the commission must consider the maximum development potential of the site if the change is granted. And what are the voting requirements? A majority vote of the entire commission is required. That's 5 votes. At certain times, a supermajority is required, or that's 2/3 of the votes of the entire commission. And that's if a protest petition is filed at or before a hearing by owners of 20% of the lots included in the proposed zone change, or by lots within 500 feet of the subject property. And further in the outline, there'll be further discussion about planning commission referral requirements with other agencies. So essentially, the zoning commission has to consider the consistency with the plan of conservation and development, look at the plan, read the sections. This is under section 10-I when voting on things. And then we'll look at the general criteria and the specific criteria for changes that are noted in the statutes. So this concludes my portion of the presentation. Attorney Casagrande will go through the rest of the slides with you. And thank you. And if you have any questions, I'm happy to answer them for you at the end of the presentation.
Thank you very much. Appreciate it.
Oh, you're welcome, Mr. Haddon.
Attorney Casagrande.
The new Corporation Council, let me join with Attorney Edwards in welcoming all the new members of the commission. And as Robin said, we're available to you to answer any questions, and we look forward to working with you over your term.
Thank you.
So my portion is more of the administrative processes, and and when you're reading through this outline, you may ask, well, why do we care about things like site plans, special exceptions, which are within the purview of the Planning Commission, and things which are not generally within the Zoning Commission's purview. And our goal in presenting this is to give you just an idea of what the respective purview is of the Zoning Commission, the Planning Commission, the Planning and Zoning Department, because you're going to hear this in petitions that come up. So we thought it would be helpful for you if you were just generally familiar with the concepts. So the first concept of administrative review is what's called a site plan. A site plan is under the 8-3 of the statutes and the zoning regulations. It's a plan that's submitted just to the Planning and Zoning Department that shows a proposed use on a specific site and shows all information required by the regulations for such use. A site plan, which again is within the purview of the Planning and Zoning Department, is required for all permitted and special exception and special permit uses, with the exception of 1 to 3 family dwellings. You don't need a site plan for that. And the site plan must meet all requirements of the regulations in order for the Planning and Zoning Department to approve it. The Planning and Zoning Department can approve a site plan, modify it to comply with the regs, or it can deny it. And a site plan, however, can only be modified or denied by the Planning and Zoning Department if it fails to comply with requirements already set forth in the zoning regulations or as applicable in the inland wetlands regs, which is within the purview of the Environmental Impact Commission. And the decision has to be made on specific criteria already set forth in the regulations. It's a very limited, narrow standard of review that the Planning and Zoning Department has to apply in reviewing site plans. If a particular use is permitted as of right in the zone, in other words, without getting a special exception or a special permit, a conclusive presumption arises that such a use will not adversely affect off-site traffic. And Section 10D11 of the regs does allow the Planning and Zoning Department to inquire whether ingress or egress to the site will adversely affect the normal flow of or normal safe conditions of the roadways. But this doesn't mean that the Planning and Zoning Department has the authority to deny a site plan based on off-site traffic volumes and patterns. The idea is when the Zoning Commission made this use permitted as of right, it had already determined as a legislative matter that the use will not affect off-site traffic issues. Again, a very narrow scope of review. The next administrative concept is special permits and special exceptions. Those are essentially interchangeable terms under Connecticut zoning law. So in Danbury, the Zoning Commission issues special permits, which is Attorney Edwards is for permits related to the retail sale of alcohol. The Planning Commission, on the other hand, has jurisdiction over special exceptions, which are enumerated in each district, and each district has provisions on what uses require special exception approval from the Planning Commission. So what's a special permit or a special exception use as compared to a use permitted as of right, i.e. a site plan use? A use permitted as of right is one for which the Zoning Commission, through the regs, has already determined that a particular use is appropriate in a particular area. That's the end of the matter. But in contrast, in reviewing a special permit or a special exception application, the commission has to determine, among other things, whether it would be compatible with the zoning district and the existing uses permitted in that zone as of right. That involves an exercise of discretion on the part of the Planning Commission or the Zoning Commission, as the case might be. One thing we added to this year's outline is you may have heard that in 2021, the legislature enacted Public Act 21-29, and that amends the zoning statute to say that zoning regulations should not be applied to deny any land use application on the basis of a district's character unless such character is expressly articulated in the regulations by clear and explicit physical standards for site work and structure. Not a model of clarity by the legislature in the wording that they chose, but the apparent intent of the legislature was to take out so-called considerations of character from zoning decisions based on the propensity of the use of that term by some commissions to encourage discriminatory zoning decisions and development. And the commission amended our regs to track the statutory language that's in 10C4A. But the legislative history is very clear that the zoning commission and planning commissions continue to retain wide discretion over zoning decisions, including but not limited to considerations of historic preservation, environmental impact, density, location, and suitability of uses. So you may have some opponents or applicants coming before you say, you can't consider the character of the district anymore. Okay, fine. But you can still consider the location, the density, the suitability of the use compared to other uses in the district. So, for example, a beer pub that or a tavern that is proposed to abut a residential zone, you can consider the effect on the residential zone of that beer pub or that tavern, based on those consider basic principles. So, a basic principle of the special permit, special exception process is that those kinds of uses may generally be compatible with permitted uses in a district, but because of their specific nature, their particular location, the amount of traffic that they generate, and their operation in the particular neighborhood, in the particular location must be scrutinized because of considerations of topography, traffic problems, neighboring uses, etc. So it's a very site-specific inquiry when you're looking at a proposed special permit or special exception. Conversely, a special permit or special exception application must be denied if the underlying site plan does not comply with all technical requirements of the regulations. And I should back up, when a special permit or a special exception application is filed, normally they have to file a site plan with that application, but because it is within the purview of the planning commission or the zoning commission, the site plan still has to comply with all technical requirements. So, for example, let's say you get a special exception or special permit application that meets all the general standards of the regulations. It'll be suitable. It will not be too dense. It won't be too concentrated. It won't affect traffic. But let's say the site plan doesn't meet the setback requirements of the zone. You got to deny it, even though it meets all the general standards. So the more interesting question that this gives rise to is, can a commission deny an application, special permit application, based on those general standards without any evidence of any adverse effect of the proposed use at its particular location in the particular district? Well, our Supreme Court answered that question last year in McLaughlin versus Bethel Planning and Zoning Commission, which you may remember, that was a very controversial case involving a crematory that was proposed in what's the name of the park? Francis Clark Industrial Park in Bethel. And the evidence, and I was fortunate enough to participate in that litigation, and the evidence of the opponents to the crematory was basically, we don't like crematories because they have a stigma attached to them. And they said, well, we're going to move out of town. We're not going to do any businesses. And the Supreme Court said, no, that kind of evidence is not substantial evidence. In order to uphold a decision to deny a special permit, there has to be substantial evidence in the record to support the denial. And substantial evidence is not general environmental impacts, mere speculation, or general concerns. And so, for example, many people before the zoning commission hearing in that case, they get up and said, well, even though my property is a half a mile away, I think it's going to affect my property values and I'm moving out of town. Well, they had no appraisals or anything to support that, which the Supreme Court basically said, that's just mere speculation. It's mere conjecture. It does not rise to the level of substantial evidence. So you'll hear that concept when you're deciding on special permit applications. You have to have substantial evidence either way, either to deny the application or to approve it. Section 10C4 of the regs sets forth the standards to grant a special permit or exception. I think Sharon's outline goes through this and Robin touched on it. But basically, under 10C4, which you have to consider when you're looking at a special permit application, you cannot grant it unless you find that four things. I'm not going to read them, but you have to find that all four of those conditions are met, or else you must deny the application. Some additional standards for special permits involving alcohol sales. We've already touched on that. I won't belabor the point, but if you look at section 3F of the regulations, there are certain findings that your commission, the zoning commission, has to make in order to allow us or grant a special permit for alcohol related uses. And we commend that to your attention. I would note that the planning and zoning department under the regs has to approve or waive under certain circumstances a site plan before a special permit application may be filed. So it's kind of a two-step process. Very quickly, I wanted to focus on the overlapping jurisdiction of land use agencies and some of the notice and referral requirements. So when you get an application in to adopt or amend the zoning regs or the boundaries of the map, you, the commission, have to refer that application to the planning commission at least 35 days before the start of the hearing. That's by statute. The planning commission then reviews the proposal and issues a report to you on whether the application is consistent with the plan of compensation development, which Attorney Edwards already discussed, and any other factors that the planning commission may deem relevant. And this is one of those technical things that you got to be aware of. And I know Sharon and Joanne and Jennifer are always looking out for this, but the planning commission's report has to be submitted prior to or at the zoning commission's public hearing, and it has to be read aloud at the zoning commission hearing. If the planning commission does not issue a report, their approval is implied. It's deemed to be implied. But if they issue a negative recommendation, then you can only amend the regs or the map by a vote of 2/3 of the entire membership of the commission, or 6 votes. And there's one old Superior Court case, which it still is good law. If the commission fails to obtain and read the planning commission's report into the hearing record, the court will overturn the adoption of the proposal. So you need to keep that in mind to make sure you get that report, if it exists, into the hearing record. Very quickly, we refer to instances in which you have to refer applications to adjoining municipalities. I won't read that to you. Basically, if a project is for any site, any portion of which is within 500 feet of the boundary of the adjacent municipality, or if the traffic, sewer, or water drainage or runoff will have impacts on the adjoining municipality, that you have to refer it to the adjoining municipality. This statute appears not to apply to zone changes, though. We just wanted to point that out. Also, there are circumstances when you're required to give notice to the regional planning agency for changes in regular boundaries that affect the use of a zone within 500 feet of another municipality. Notice by the applicant to water companies. The applicant has the burden regarding any project on any site within the watershed of a water company to refer the application to the water company, provided there's a map on file with the city showing the boundaries of the watershed. And lastly, wetlands, which is within the jurisdiction of the city's Environmental Impact Commission. It too is created by charter. If any application for a boundary change involves a site on which there are wetlands or watercourses, the commission should review whether section 8-2 factors are implicated. In other words, is it in the public health and safety or welfare to allow a zone change text change or map change when it may have a deleterious impact on wetlands. And if an application for a special permit or a special exception involves a regulated wetlands activity, which is defined in the EIC's wetlands regulations, the applicant has to submit its wetlands application to the EIC no later than the day it files its application for a special permit or special exception application with the zoning commission or the planning commission. And in those circumstances, you have to wait for the EIC's decision and give what's called due consideration to its findings. Last thing I want to talk about is protecting the decision. Problem issues. You have to, as a trial lawyer, I'm always looking to make sure that the record is that the record is clear and adequate, so that if anyone takes an appeal to an appellate court, in this case the Superior Court, from a decision by a zoning commission, those issues are addressed, and we can argue that they are without merit before the Superior Court. So what are the problem issues that come up? One is participation in the hearing process. And a cardinal principle of the public hearing process is that every member of the public has a right to inspect all documents and plans submitted. Those include all written reports and comments in the hearing record. As we've talked about to prior commissions, you should take the time, especially, and Chairman Haddad is very good at this, to make sure that every exhibit gets logged in, identified with particularity with an exhibit number. Read aloud all agency planning, regional planning agency and planning commission reports on zone changes or other municipal reports. Make sure every speaker is identified, gives their name, and give interested persons, in other words, opponents or the applicants, a fair opportunity to comment, introduce evidence and exhibits, and the parties must be allowed to examine and cross-examine witnesses. Now, normally, under Robert's rules, an attorney or an opponent can't just turn to the person who's testifying and say, I want to ask you these questions. All cross-examination questions should be directed through the chair. In other words, through the chair, may I ask the witness this question? So it preserves essentially the civility and the dignity of the proceedings. You should adopt and adhere to a basic protocol for conducting the hearing. In other words, Robert's rules. I believe your bylaws incorporate Robert's rules as the appropriate parliamentary procedures. All questions from the members of the commission should be directed to the chair, as well as from members of the public. People should speak clearly and do not speak until you're recognized by the chair. Again, the purpose is to protect the clarity of the record, because someday a court may be reviewing that transcript and you want to make sure it's as clear as it can be. Bottom line is always try to create a clean, organized record for appeal. Assume that every decision is going to get appealed. Next topic is ex parte communications. What are they? Those are communications outside the hearing room. And that means communications that the zoning commission members may have among themselves outside the hearing room, or they may be approached by the applicant or opponents or members of the public. You should avoid those communications at all times, because what happens is, if those ex parte communications are held and it is revealed that they were held, that creates a presumption that the commissioner who had those ex parte communications is prejudiced and has prejudged the application. And what happens in an appeal from a decision where the appellant raises an issue of ex parte communications is, if it establishes that those ex parte communications took place, what that does is it switches the burden from the applicant to show that the application was wrongly decided. It switches the burden on the commission to prove that the communication did not affect the decision. You don't want to put your fellow members or the commission in that position under any circumstances. So what do? Somebody calls you up on the phone, sends you an email. You should simply decline to discuss the matter. Say, I can't do it. Corporation Counsel tells me I can't do it. Put the contact on the record. Just to be clear, I was contacted by Mr. Smith or Mrs. Smith, and they said this, and I told them I cannot discuss it. And you should, again, as I said, I said you should avoid even communications among commission members. You know, sometimes you're tempted to get on the phone after the hearing or have lunch and talk about it. You should avoid those at all, in all contexts. No emails, no texts, anything. If you have a question on the application, contact the staff. But when you start engaging with unilateral communications with other commission members, it jeopardizes the record and jeopardizes your decision on appeal. Receipt of post-hearing evidence. Once the hearing is closed, it's closed. You cannot consider evidence, including public comments, after the hearing is closed. And again, if you do that, you're jeopardizing the decision, because receipt and consideration of that evidence can invalidate the decision by a court on the appeal. And the common sense basis for this rule is that consideration of any post-hearing evidence denies the applicant or the opponent's due process. Again, the fundamental rule is you have to give fundamental fairness. It's not constitutional due process in the constitutional sense, but basically you have to act so as to give fundamental fairness to all participants in the process. So if you get anything from the applicant or the public after the close of the hearing, give it to the staff and note on the record that you have not considered it. Now, there's an exception to the prohibition of receiving post-hearing evidence. You can receive staff reports, you can receive engineering reports, you can receive the report of the planning director, as long as that report of those reports do not contain any information that was not already in the public record. And Director Colitro and Jennifer Eminger are always very careful when they give post-hearing reports to say, our comments are based on evidence that is already in the record. We have not considered any new evidence. And similarly, if you get an opinion from our office, the Corporation Counsel's office, that's legal advice. That is not considered post-hearing evidence. But again, we're very careful if we're asked to do an opinion letter after the hearing closes, not to include any additional evidence. So for example, if an attorney calls us up and says, hey, can you put this into your opinion letter? No, you can't if it wasn't in the hearing record. The staff's role. The planning and zoning department's role is to act as your advisor and consultant. It provides guidance on technical issues, city policies, precedents and procedures, and historical information on the regulations in our particular sites. And it's important to understand the differing roles of staff, they're your consultants. They guide you in the process, versus representatives of a petitioner or opponents. Their job is to advocate for their clients. The planning and zoning department's job is to guide you through the process. And there was a case that came down, believe it or not, 4 years ago, that Sharon Colitro was involved in. And I'll just note it's an excellent case study on the respective powers of planning and zoning commissions. And the case summarizes the role of a planning director and staff in providing professional guidance to commissions. And it summarily rejected the applicant's claim. This is a Dunkin' Donuts project. I forget the location of it, but the appellant claimed that the Director Colitro was biased in her professional recommendations to the commission, which is, anyone who knows Sharon knows that that's nonsense out of the gate. And I include the excerpt from the court's opinion. I'm not going to read it to you, but it's interesting reading. But basically, the court said the record is devoid of evidence that Colitro had any personal or financial interest in the proposed change, or that she harbored any animus toward the applicant who submitted the proposal. I submit to you that that decision is a very fitting swan song for Sharon's departure as one of our best planning directors in the city's history. Just a couple more things. Testimony by experts. You may get experts to testify, traffic engineers, civil engineers, etc. But you're the commission. You don't have to believe any expert. You're the judge of the credibility of witnesses before you, even including experts. Having said that, though, as to technical matters, you cannot ignore the only expert evidence on a technical issue without putting on the record the basis for your disagreement with that expert and allowing the applicant and the public an opportunity to address those concerns that you may have with what the expert is telling you. If you as a commission intend to use your own expertise or knowledge of a site, you must disclose that expertise on the record during the hearing. You know, I'm a soil scientist, I'm a civil engineer, and put that on the record and say, this is what I'm thinking of as a commission member. These are the material facts on which I'm relying based on my expertise, and you got to give the applicant a chance to rebut or respond to those. Having said that, the commission may rely on its own knowledge and experience and observations of a site. And this is especially true in matters involving traffic, congestion, and traffic safety. Every member of the commission knows the community. They know the roads. They know the condition of the roads. And as a general matter, you can rely on your own knowledge without having to rely on expert testimony. Very quickly on site visits, I'll just go through this quickly. They're allowed and appropriate. It's not part of the public hearing, so you don't need to notice them as a public hearing. But if you do a site visit, you should, at the next hearing session, if there is a public hearing, disclose any knowledge or information that you learned on the site visit. You should, if you're going on a site visit, you should not ask any questions about the substance of the application. You're not there at the site visit to listen to comments or questions from the applicant or the public. Those are the best forum for that is you reconvene the public hearing and then you address those comments. If a quorum of members plans to attend the site inspection, that should be noticed as a special meeting open to the public. And if the landowner, sometimes landowners won't allow you to do a site visit or to allow the public to go and attend the site inspection, that could be deemed an illegal violation of the Freedom of Information laws as an illegal closed meeting. You can't have a meeting that's closed to the public. Rights of members absent from the hearing to participate in the decision. Sometimes you can't show up at the hearing. In that situation, in order to vote on the petition, the member or a duly seated alternate has to review the entire record, including all the exhibits and the hearing tapes, and state that on the record in order to be able to vote on an application at which you were not present at the hearing. If you don't do that, again, it sets up another basis for someone to argue to a court that that member was disqualified and shouldn't have voted, and it throws the whole decision out. Alternates can participate in the public hearing, but if not seated for the decision, they may not participate in the decision process. In other words, if you're not seated for the decision session, you can't participate in the discussion or ask any questions. Conflicts of interest and disqualification. I mentioned prejudgment. It cannot be overstated how important it is to avoid the implication that you've prejudged an application. So do not, during the hearing, take a public position on what you feel about an application, either before the application has been heard or the hearing is over. Now, that doesn't mean that you can't ask questions of an applicant or an opponent during the hearing. You can express preliminary concerns, but the key point here is you have to avoid any statements that you make before or during the hearing suggesting that you've made up your mind. Accordingly, a commission member should not speak in favor of or in opposition to an application during the public hearing. That shows prejudgment and will likely get your decision overturned. There's certain statutory requirements here about when a planning commission, zoning commission member may appear for or represent any person in a matter before any of those agencies. I'll leave that to your reading. And you have to avoid situations in which you're participating in a matter in which you as a member are directly or indirectly interested in a personal or financial sense. And what we've advised commission members over all these years is if you have any doubt whether you have a conflict, get out. That's why you have alternates. Don't jeopardize the decision. And finally, the decision, as Robin has already articulated, you need to adhere to the standards and the criteria set forth in the regs. You should, especially in controversial applications like we dealt with on the Pacific House last year, very controversial. You should adopt a collective statement of reasons. In other words, what you would do is you'd ask the planning department. Sometimes you would ask the planning department to prepare a proposed resolution of approval, as well as a proposed resolution of denial. That happens all the time on complex matters, and it's perfectly appropriate to do that. But you have to adopt a motion to approve the resolution as a whole. If everybody just gives their individual comments, well, I don't like the application, or I like this application, and then everybody takes a vote, that's not a general statement of the collective reasons of the commission. Again, the statement of an individual's member's reasons, his or her own reasons, is not the collective reason of the commission. And the better practice is state the reasons. That focuses the commission on the evidence and on the standards as set out in the regulations. And it's immensely helpful to me as an appellate lawyer when I go to defend that situation, because that collective statement of reasoning tells the court exactly what you did and why you did it. That concludes our presentation, Mr. Chairman. Again, we're happy to entertain any questions, and thank you all for your dedication and service to the city.
Thank you. Thank you, Attorney Casagrande. Fascinating as always. I appreciate it. Also, Attorney Edwards, thank you so much. So let me ask any of the commission members if they have any questions at this time of Attorney Casagrande, Attorney Edwards, Ms. Calitro, on anything that they heard tonight, or even if there was something that wasn't mentioned tonight that they have in the back of their mind that they're curious about. I see Commissioner Botello, please.
Yes, Attorney Casagrande. Just more edification for the site visit. Is it considered trespassing if you just go to the site without permission from the applicant?
Yeah, you have to get the owner's permission. You can't just go there. You have to get his permission.
Okay, and in doing so, but you're not supposed to have any conversation with them. It's just, I'm going to, if you allow me to come by your property, I'm just going to drive by on my own. We're not supposed to have a get together with the applicant.
That's right.
Okay, just wanted to make sure that was clear.
You can add, for example, you could say, we did this on the summit a few years ago. We actually went out to the old Carbide headquarters and we got a tour of the building. But basically, what we told the commission members is, you can ask, what's this? Where's this? What is that room? You know, general questions like that. But you can't get into a dialogue with the applicant or the other people attending the site walk on, is this a good thing? Does this comply with the regs? That has to wait for the public hearing.
Okay. Thank you.
Thank you, Commissioner Botello, Attorney Casagrande. Also, Attorney Casagrande, I believe that summit meeting, when more than one commission member is present, it was actually a public hearing. We actually posted that or advertised that, right?
We didn't post it as a public hearing, but it was posted as a meeting of the commission.
As a meeting, right. Yeah.
Right.
Commission members, anything else? If I can, Attorney Casagrande, I took a couple notes for tonight. I noticed on page 35, H1, when I call on a commission member, I don't know, obviously don't know what they're going to say. So sometimes in the past, when I would call anyone wishing to speak in favor of the petition, it's really not advisable for a commission member to raise their hand and speak at that time. It's always best to form your opinion after you've heard those in favor, those opposed, seen all the exhibits, read all the documents, and have pretty much exhausted as far as you could go the length of a meeting before you should make a comment like that. Clearly not speaking in favor or opposition when it's called, right?
That's correct. Wait till after the hearing is closed before you start giving your views on whether it should be approved or denied.
And clearly, sometimes during questioning, somebody can see that you're not purposely telegraphing your opinion, but sometimes on the questions that a commission member may ask, somebody can see how they believe it,
Yeah.
how they feel about it. But you shouldn't be emphatic about announcing how you feel about it, really. So I wanted to clarify that because we need to tune up a little bit on that here. The other thing, it's not written anywhere, Attorney Casagrande, but I'm funny this way. I've never really called you anything other than Attorney Casagrande while we're in a public hearing, or Ms. Calitro, anything other than Ms. Calitro, and I don't call commission members by their first name. I clearly don't call any attorneys or anybody speaking by their first name because I don't want the public to think that there's a friendship or a familiarity, whether there is or whether there isn't, or to deceive the public thinking like, they went to school together or they're friends or they do business together. So I'd like to ask some of the commission members always to not, if they see Attorney Marcus standing up to say, "Hi, Neil, how are you?" Or, "Neil, let me ask you this question." It's Attorney Marcus. I'm a firm believer of that. And is that something that you recommend as well?
Yeah, I think it's just a matter of protocol and preserves the dignity of the proceeding. It's just like when you're in a meeting with the mayor. If the mayor is your friend, you call him your honor or mayor. You want to have a beer later, you can call them by their first name. But I agree with you 100%.
Yeah. So I know that sometimes we have a tendency to just because we're all Danbury people and we all know a lot of people, and they come up and they speak in favor, they speak in opposition, and I wouldn't want the public to see anything. A lot of this commission, besides doing what we do, Danbury used to be very small, and this commission did for Danbury. Danbury is in an area right now where we not only do for Danbury, but Danbury, Bethel, Brookfield, New Fairfield, Brewster, the surrounding towns look to us for leadership, look for our decisions, look how we deal with things. And so it's public perception. We always want to be as professional as possible, as correct as possible, and really to know the Connecticut general statutes, know our regs, know the procedures. So
it's called avoiding the appearance of impropriety or favoritism. That should be a guiding principle.
Yeah, thank you. Commission members, anything else at this time? Some of the documents that we didn't read from page to page that we have tonight here are also the bylaws and procedures and information. It's also very interesting reading. For the new commission members, our procedure is generally when we have a new public hearing, we read the legal notice, we read the public hearing into the record. There's documents that go with that. The planning commission recommendation, usually something from the WestCog, but when we do open of course we get the staff report. When we do open the meeting, we generally ask for those wishing to speak in favor of the petition. It's usually the attorney for the petitioner, and then we'll ask our commission members if there's any questions of him at that time, of him or her at that time. We'll then ask if there's any others wishing to speak in favor, and I'll clarify that by saying it several times to make sure that the room is exhausted. And then we go to those wishing to speak in opposition, and then we ask the representative or the attorney for anything in closing, anything in rebuttal, maybe if they had some opposition or rebuttal remarks. I'll ask then for Ms. Calitro to make any final comments. And then the commission has a choice. The choice is to close the public hearing at that time, or to continue it, for a specific reason. So that's generally how our meetings run, or how the public hearings are held and how the petitions are presented. Commission members, anything else of Attorney Casagrande, Attorney Edwards, or Ms. Calitro at this time? I think we're good for now, and always it's deeply appreciated, Attorney Cascarani and Attorney Edwards, for you to come out here and do this. It's always very useful. Silly question. Your
Chairman had it. Yeah,
Oh.
sorry. Go ahead.
I was just gonna say, the presentation that we had on screen share, is that something that's we have that's emailable, or?
Yes, we will email it to all of you tomorrow or Thursday. So you have a hard copy of it. And I just wanted to touch base a little bit, if I can, Mr. Chairman, just about the training requirements.
Yes.
So there, as Attorney Casagrande and Attorney Edwards indicated, Public Act 2021-29 made some changes to the zoning statutes. And part of that included a requirement for training for land use commissions. And then there was a follow-up public act in this year, 2023-173, which updated some of the requirements. And basically, it does require that commissioners, the zoning commission, the ZBA, and the planning commission have 4 hours of training every 4 years. And on certain topics. You can note, and I've been tracking the time tonight, so I would say that you have 1 hour of the 4 covered for all of you. But and there are opportunities which I will share links to get your other trainings, as I indicated when we started on the webinar. But and I think the genesis was that people who are serving and volunteering just are trained on a regular basis. Jennifer and I have certification credits. We have to maintain our planning certification. The attorneys have educational training credits that they have to do as well. And I think they just wanted the throughout the state for land use commissioners to say, yes, I've been, I've taken a training course in XYZ topic. I can send you the Office of Policy and Management training guidelines, which I will do, updated for the current Public Act. It gives you an idea of the things that or topics to be trained on. There's a requirement for at least 1 hour on a topic of affordable housing. There is a video available that's just over an hour. If you want to watch it, you'll get that hour. And there'll be other opportunities throughout the year. As I indicated at the beginning, for the commissioners that were reelected, and they were in office as of January 23rd and are reelected January 1st, 2023. So Commissioner Haddad, Commissioner Jowdy, their requirement was to through December 31st. So they had a year, so that's the end of this month, to get their 4 hours of training. They participated in a course, an online course in March, so they obtained their 4 hours. Commissioners Botello and Bennett were appointed to the commission in September and now reelected again, but because of their September date, they have a year from their September date. So Bob and Bruce, you have until next September, and the rest of the new commission members have until December 31st, 2024. So what happens then? I guess that's the big question. So we will, under the statutes now, we have to report, the commissions have to report to the city council by March 1st that you've completed your training. It's a self-certification. We will, the department will prepare a form, we'll send it out to those who are required to have the training by the end of 2023. We'll ask you to sign the form. We'll just submit it to city council. There's no, they're not going to ask questions about it. I don't think it even shows up on a council agenda. It's just a requirement that you have to certify to the legislative body of the municipality by March 1st that by your time period, you've done the 4 hours of training. I also, on the other side of the spectrum, I don't know what the state will do, because if you say, no, I didn't do it, they haven't outlined any repercussions in any way, shape, or form. I would just urge you to try to we'll give you the opportunities, we'll send along the links, things to watch. You don't have to go anywhere. You can watch some videos. Yukon Clear has a training academy. You can log on and do that. As I indicated, you all get an hour for tonight, which is a good thing. So you only have 3 over the course of the next 12 months for the new members. But that is something that we're going to we're required to, kind of keep up on, and you're required to report. Not just you, but the Planning Commission has to do it in the Zoning Board of Appeals. So again, we'll be creating a form. We're going to email it to you, sign it, send it back in, and we'll deliver everything to the City Council by February. And we will continue to send you links and updates and opportunities. WestCog is in this month of December hosting a couple of training sessions. We can send you the links to those to see if you want to attend. But I would urge you, the knowledge is power all the way around, and training is a good thing. And again, our office is available and open to any questions you might have on how you can get your credits and things like that. So we're here for you, as I indicated before, and we'll send you all that information via email.
Thank you. So can I present something to you, Ms. Calitro, that maybe Attorney Cascarani or Attorney Edwards wants to comment on? I don't really know how I feel about this, but I will tell you that 1 or 2 days after the election, I got 3 emails from 3 different groups of third-party groups in Connecticut, having nothing at all to do with Danbury's, the Danbury Zoning Commissioner of the City of Danbury, asking to go to their training programs on the regionalization of zoning and the elimination of zoning on a municipal basis. There was a couple other groups. Can I say here that commission members should only be directed to the training program that comes from your office? I mean,
Well,
should our members be seeking training in areas that have nothing to do with Danbury?
I guess I would just caution, and the attorneys can jump in. I would just caution about if somebody reaches out to you that's not either from us or you'll get the email from the department on opportunities from training, either from Western Connecticut Council of Governments, for which Danbury is part of, for those of you who don't know. And they're holding training sessions for all the communities. But there are groups that advocate for certain zoning related reforms, and they get your name and number, and they request you to attend. We can't stop you from doing certain things. I would just say that it's probably more appropriate to seek training through like Yukon, the Center for Education and Learning, just on, rather than a specific group who has specific intents on, trying to change the landscape of zoning.
Yeah, I was trying to be as gentle as possible. My email said, let us show you the right way to do zoning.
Yeah.
And I clearly did not buy into that. So I was just a little concerned with some of the newer members here that know that education is required. And it's maybe just very easy to log on to something like that to get those hours in, but I'm not sure that's the right place to go.
You can always feel free to contact the office, contact me, contact Jen after I'm gone, or Joanne, and say, what do you think about this?
Yeah, I'd love that to happen.
And we can say that's a group and they're involved in this, or go on their website and see. I would tend to steer the commission members to kind of our organizations that we're part of, or something like Yukon, like a WestCon Training Center, WestCon Training, or Yukon Clear, or again, it's just it's probably just a safer avenue. I mean, you could always belong to, participate in on your own, but in terms of the training, I think you're better off kind of
All right, so commission members, if
Thank you.
anybody gets anything like that, you're welcome to run it by the office.
Yeah, I don't know if Dan and Robin want to chime
Yeah,
in
I was
either.
just gonna say, Attorney Cascarani, Attorney Edwards, any comments on that?
No, I just say one thing. I'm looking at the just the public act. I just have it pulled up on my computer, and as Sharon mentioned, it has to be 1 hour of affordable housing policies, and then it just goes on to suggest that it can also be about process and procedural matters, including the conduct of meetings, things related to the Freedom of Information Act. It has to do with the interpretation of site plans, surveys, maps, and architectural conventions, the impact of zoning on the environment, agricultural, and historic resources. So I think the trainings that Sharon's mentioning will all be oriented towards those types of things that are mentioned in the Public Act. So that's just a little bit more helpful guidance, I think, to kind of bolsters with what Sharon had just stated.
Thank you.
Yeah, and I think once I send the guidelines, some of your old commission members have gotten them before, but the new commission members, the land use training guidelines that we got from OPM will outline. That's what Robin was reading from. It'll give you the list of topics, for example, to look for. And what I've done over the past couple of months is I've gone on the Yukon Clear site and I've found the webinar and I get the link and I send it to you guys and I said, hey, here's something on XYZ. Why don't you watch this for an hour? Or here's an opportunity if you need it. So we'll continue to do that, as staff to all commissions.
Thank you. Thank you. Commission members, any other questions or comments? I don't see any hands. I don't know if anybody want to unmute. If anybody has anything to say, I'll ask again. Anything else, commission members? Commissioner Jowdy? Maybe? No?
Yeah.
Oh, good. Go ahead, Commissioner Jowdy.
Okay. Thank you, Attorney Edwards and Attorney Casagrande. Again, I've heard you, for being on the commission many years, I've heard you address the commission and you always do a great job. And thanks again.
Thank you. Thank you, Commissioner Jowdy. Anything else, commission members? Okay, so I think we're good with Attorney Casagrande and Attorney Edwards at this time. Appreciate it again. Once again, thank you so much. Always good to see you and always good to hear from you. Appreciate it.
Thank you.
I don't think we have, Ms. Calitro, anything else? I mean, the
I
only
don't
other
believe
thing
so, Mr. Chairman, no.
yeah, the only other thing was just I had as a note here was procedures and information, but we already talked about that. So we don't have any public hearings, we don't have any continuation of any public hearings. We don't have anything under old business for discussion, possible action, nothing under new business, nothing for reference only. So I'll ask the commission members, this is open to anything that you have in your mind under other matters. Are there any other matters? Are there any other matters? Commissioner Botello.
A question to Ms. Calitro, is there anything in the pipeline that's going to be coming up in January or February that you know of?
Good question.
We might have a special permit application for, I believe, a restaurant liquor permit in January, but I have to double check with Joanne, make sure everything's in on time and we can get that notice. But yeah, nothing as very significant as we've had over the last couple of months that I'm aware of.
Oh, that's good to hear.
Give the commissioner a little bit of rest.
Yes.
Yeah.
It was pretty heavy the last quarter of last year. I'll tell
To
you.
break in all the newbies is a good thing.
Yeah, right. Anything else, commission members? Anything else? So as I said and mentioned before, we're done for this year.
You know what, Mr. Chairman, if I can, I'm sorry.
Sure.
Let me just also say, we talked about the zoning regulations, but there is a zoning map obviously associated with that. We update it every couple of years, depends on the activity. And then it's uploaded to the website. We can make copies for you. It's fairly large, but we are in the process because the planning commission a couple of weeks ago approved the mall, the zone change that affects the properties of the Danbury Mall. So that's our last change that we're having made. So we'll get the map done and it'll be dated through December 31st, 2023. And, depending on, the amount of activity, it might take a couple of years before we do it again. We probably do it once every 2 years. Again, if you need copies of it, we can get copies. We have a print made that we can run copies from internally, but you can always go online on the GIS and zoom in. Everything's up to date. So you can, and it's in color, so you can see the different zoning districts in color, so you can tell what lots are zoned what. There is no formal action on adoption of that map because the map has been adopted, and your changes to it that are approved over time are though obviously approved. So this is a ministerial act of actually physically changing the map. And that occurs, like I said, every couple of years. So we'll take care of that through the end of this year.
Sharon, is it possible to get it done so that in a PDF form so we can send it to a printer and get it to a 3x4 if we want it?
Yeah, it's in a PDF form. We get it from the mapping people in a PDF form. It's going to be super small to try to read it that way. I mean,
if it sends
seen the one in my
PDF,
office, it's 5 feet by 4 feet by 3 feet. But you can go online and zoom in. You can see any property you want.
well,
It's better actually to do that than to print it, I would say.
To get the whole, but you get the whole city. You want to get the whole city in one map, like you used to be.
Yeah, but I would say it's almost unreadable even on an 11 by 17.
No, I'm talking about making it like a 2x3 or 3x4.
Oh yeah, you can do that. Yeah, we can get you the PDF.
Yeah, please. I'll send it to my printer.
We'll run you copies we'll run copies for you. So let us get it updated, and in January when we actually have it, we can send around. Here's the PDF. You can do with it what you want, or you can ask us to run you a copy of it, whatever you want.
Perfect. Okay.
But it will be uploaded, and it will be on the website once it's done.
Great.
Okay, thank you.
So let me just say before we close, commission members, take a look at the zoning commission member list of December 2023 that was sent out. Just double check it all, email addresses. Let me ask you, did everybody got their email of the agenda in the right spot? Everybody got it? Everybody figured out how to find a link and do all that stuff? And then yes. Ms. Reed, if I can ask you, we're going to try and work on getting ID badges this time around. Sometimes when
I will follow up on that, Mr. Chairman, with the new mayor to make sure that he's going to be, because the previous mayor said it was okay to have ID badges, which you could use if you went out for an on-site. It won't allow you to do anything else, but it'll identify you as a zoning commission member and it'll have your picture. Yeah. So I will follow up with them and make sure that's still going to be something that we can do. Yeah. And
we don't need access.
I would let you know. You'd have to come in and have your photo taken, and then you'd be given the little white card,
Yeah.
And also, I just wanted to mention that a lot of what they talked about tonight was in my memo, but my memo also has the links and stuff that you need. So if you have any questions, just email me. My email's always open. I'm always there. And, sure. I can answer questions whenever you want.
Thank you. Anything, commission members?
That's it. Well, except Joanne, is it possible to use the post office picture that we have?
Yeah, sure, Bobby.
Okay.
Cute, very cute.
Nice.
Also, Ms. Eminger, good to see you tonight as well.
Hope you're feeling better.
Yes, I hope so. And your husband too, right?
Yeah, thank you. Appreciate it. We're getting there.
So I'll say Merry Christmas to everyone, because next time we see each other is January 9th. And of course, I'm always available. If anybody needs me, you can call me at any time. I think everybody has my cell phone, email address, and all
actually,
that.
It's not on the roster. Its cell phone is not available.
Yeah, I saw that, but
I have to update it. I just wanted to get it out to you guys because to begin with, I couldn't get the names of everybody that won. And when I finally did, then I had to go to the town committee chairman to get your emails. And I didn't know if those were the right emails or not that you wanted to use. And so I'm going to update the list and reissue it. That was just a tentative, that's why. And like I said, I don't give that information. I don't give your phone number or your email out to anybody. If anybody wants to try and send you something, I try to encourage them to send it to the office and I can get it to you, or they have your home address, but a lot of times if we have something controversial come up, you might get a lot of stuff in the mail from people. And it's not something that, you know,
Yeah.
you're gonna want to use or consider, but you want to acknowledge that you received it. So that's why I don't give out your phone numbers or your emails.
Appreciate it. Thank you.
Okay.
Anything else, commission members? So let's see, who wants to make a motion to adjourn the public?
Make a motion to adjourn and have a good holiday.
Mr. Botello makes a motion to adjourn. Is there a second? Second by Commissioner Bennett. Any discussion? All those in favor signify by saying aye.
Aye.
Those
Aye.
opposed. Let the record show at 9:19, our first meeting has concluded. Thank you, everyone. Have a nice Christmas.
Thank you.
Thank
Good
you.
night.
Happy
Happy
holidays.
holidays.
If
Good
there
night,
needs anything, let
everybody.
me know.
Bye, everyone.
Bye.
Bye.